everybody. Thank you all for being here. We are really grateful this morning that we're going to be able to understand the resources that Austin Tenants Council provides. We've all endured a really difficult year, and we know that the right resources during a crisis can be a major lifesaver. Operating under the philosophy that everyone has a right to safe, decent, and fair housing, the Austin Tenants Council fulfills thousands of requests each year for help with housing problems. Austin Tenants Council programs focus on housing discrimination, tenant-landlord education and information, and housing repair and rehabilitation. Their mission is to ensure housing stability by rectifying Fair Housing Act violations and empowering tenants to exercise their rights to mediation, advocacy, and education. And we're lucky to have with us today Rachel Walker, Housing Advocacy Program Specialist. Also, Sol Praxis is a housing advocate on the landlord-tenant team, and Laura Corrier, who will be conducting the Spanish for us this well. And special thanks to Tiffany Harris, our Community Vitality Coordinator for the City of San Marcos, for arranging all of this. Thank you, Tiffany. My name is Deborah Carter, and I am a librarian at the San Marcos Public Library. So Rachel, I have some questions for you that I understand folks out there commonly have for the Austin Tenants Council. And we are definitely grateful for your time and expertise in helping us understand these questions. My first question for you is, I am behind on my rent and received a notice to vacate. What legal protections do I have during the COVID pandemic?
Yeah, so a notice to vacate is the first step in the eviction process. Basically, it is a statement that the landlord would provide a tenant in writing, claiming that the tenant has breached their lease and asking them to move out before an eviction would be filed. So when a landlord gives a notice to vacate, that is the start of the eviction process. However, right now, there are some protections in place for tenants. So first, if your landlord has given you a notice to vacate for non-payment of rent, you would want to make sure that you are aware of local and federal protections that are in place, because there's a good chance that if you've received a notice to vacate for non-payment, that you may be covered by some protections. Locally in San Marcos, tenants have a right to cure. So there was a city council ordinance that was passed, I think, last April, giving tenants a 90-day right to cure. This is really important because normally tenants do not have a right to cure, unfortunately. So if they receive a notice to vacate, their landlord, can then pursue an eviction when that expires, usually 3 days later. But right now, before a landlord can even give a notice to vacate for non-payment, they need to give a tenant a written statement giving them 90 days to either pay back what they owe, or an eviction could be pursued after that 90-day period. So this is a notice of proposed eviction. So if you've received a notice to vacate and you live in San Marcos, but you have not received the 90-day notice of proposed eviction, then your landlord most likely has violated that local order. I would suggest, and of course, people can always reach out to us to discuss their specific situation. But if you've received a notice to vacate for non-payment and you didn't receive the 90-day notice before that, you should respond in writing. And we can always connect people with a template. I think there's one on the city website as well. You should respond in writing, asserting that this protection does exist and that you believe that you are covered, and ask your landlord to rescind the notice. You can also file a complaint with the city, because there is a penalty for a landlord wrongfully issuing a notice without first going through the notice of proposed eviction process. Beyond the local protection, the big one at the federal level is the CDC eviction moratorium. So that has fairly broad eligibility requirements. So if you receive a notice to vacate for non-payment, there's a good chance that you would be covered by the CDC eviction moratorium. Generally speaking, the eligibility for that is it's income-based, so you need to make either less than $99,000 annually or twice that if filing jointly, or have received a stimulus check, or either you that or you didn't have to file taxes because of your income. So if you meet any of those eligibility requirements and you have either lost income or had extraordinary medical costs that are resulting in you being unable to make full rent payments, then you're likely covered. There's a couple other broad eligibility requirements, like you need to make best efforts to make timely partial payments. You need to use best efforts to apply for rental assistance that's available to you. But generally speaking, you would be covered. The key thing there is that you're not covered until you give your landlord a written declaration stating that you are covered. And again, I think we have a link to that on our website, and we can always email that to people as well. But you need to give your landlord the signed CDC declaration stating that you're covered. The CDC eviction moratorium prevents a landlord from being able to pursue an eviction for non-payment of rent. So if you've received the notice to vacate and you give your landlord that, what it means is that they should not be able to proceed with filing an eviction in the Justice of the Peace Court. If they've already filed, you should also submit a copy of that to the court. The main thing to mention here is just that this is set to expire pretty soon at the end of this month. I know there is some talk that it may be extended, so people can always check back in with us, and we'll post, on our website as well, updating people if that does get extended. That, as well as, the other protections that are in place, because depending on when this happens, some of these protections may have expired, other protections may have been extended. So that's just another thing to keep in mind, is to reach out to us depending on when you reach that, and we can update you on what protections are still applicable.
Okay, that was a lot of information. Thank you so much. And we have a question from the audience. I'll read it. What happens when it does eventually expire? Will there be mass evictions?
Yeah, I mean, it's really concerning, and it's scary right now, especially being so close to the potential expiration at the end of this month. I think that there will be mass evictions unless there's other major changes providing broader protections for renters and rental assistance. There is this, threat that there will be this huge wave of evictions because so many people have been behind on rent since the beginning of the pandemic and are really vulnerable once protections are lifted.
So the city of San Marcos and the federal will both expire at the end of this month?
No, the city of San Marcos, that protection is in effect as long as the local declaration of disaster related to COVID-19 remains in effect. So that doesn't have as clear of an expiration date. It's just whenever that expires.
Okay. So when it does, after the 90 days, then you need to pay back all of that rent, or can you just start with your monthly payments?
Unfortunately, it doesn't waive any payments. That's one of the key things right now, is that none of the protections that tenants have waive payments or past missed rent payments, and they also don't waive late fees. So the notice of proposed eviction would give a tenant 90 days to pay back basically what is owed at the beginning of that time period, but also what accumulates during that time period, which unfortunately can include late fees if that's allowed by the lease and the landlord doesn't agree to waive them. So yeah, and it's possible, there's a lot of people right now who may have received notices of proposed evictions earlier in the pandemic. If they completely cure the violation, meaning they pay back everything that was owed, which obviously is not really attainable for a lot of people right now, but it does give them a right to cure. So if they pay back, the entire amount that's owed, then the landlord would need to issue another 90-day notice if they fall behind again. But if that balance remains unpaid, any portion of it, then they could proceed with the 3-day notice to vacate. But if the CDC eviction moratorium is still in effect, the tenant would still be covered by that and could issue that declaration to their landlord to, have that protection.
Okay, thank you for that clarification. It is scary to be in that situation. I have another question for you. If my landlord locks me out or tells me that I have to vacate my apartment because I am behind on rent, do I have to leave, or what options do I have?
Right. So the key thing here is that a landlord does not have the authority to make a tenant leave. So regardless of whether it's for non-payment or another issue, a tenant does have a right to remain throughout the eviction process. A landlord would need to obtain an eviction judgment, and then a few days after that, a writ of possession, in order to have the authority to make the tenant leave. And even at that point, it would be a constable from the court rather than a landlord carrying that out. So a landlord cannot lock out a tenant for non-payment in most situations. There is one instance where, like, if it's allowed by the lease, a landlord could temporarily lock a tenant out. That's pretty rare, but that would be like they'd have to provide a key within 2 hours upon the tenant's request. But that needs to be allowed by the lease, and there needs to be advance notice. So in most cases, lockouts are going to be illegal. If a tenant has been locked out, what they can do is, for immediate relief, is they can file for a writ of reentry with the Justice of the Peace Court. Sometimes people are intimidated because they have to go to the court, but it's a fairly straightforward procedure where they need to submit a sworn declaration declaring the facts of the lockout. And then, the court will review that and can send a constable who delivers the writ of reentry to the landlord, which is a court order requiring the landlord to allow the tenant back in. There is a filing fee, but if tenants have any difficulty paying that cost, they can also submit an affidavit of inability to pay to request to have those court costs waived. As far as verbal threats go, it can be really frustrating to deal with that sort of harassment from your landlord. Any sort of verbal notice to vacate is not a valid notice to vacate because per the property code, it needs to be delivered in writing. So if your landlord is verbally telling you to leave, they're likely, trying to intimidate you. I would definitely suggest documenting it and communicating with the landlord in writing about this if it gets excessive and you want to ask them to stop those behaviors. But just keep in mind that you do have a right to stay there regardless of what your landlord is saying.
Wow, okay. We have another question from the audience. What happens if a tenant re-enters their home after a lockout without going through the court?
If a tenant is able to re-enter without going through the court, that's fine if they're able to access the premises again. The court procedure is intended for tenants who aren't able to get back in. I should add though that the writ of reentry, that's supposed to be like more of a quick fix to order the landlord to allow the tenant back in. But regardless, tenants also have the opportunity to pursue further recourse. The landlord could be held liable for a civil penalty, which would be 1 month's rent plus $1,000 court costs, damages, and attorney's fees. So tenants should, in addition to doing what they can to get back in, they should also document what has happened. If they are interested in doing this, they could connect with an attorney about filing a lawsuit to hold their landlord responsible for their damages as well as a penalty.
Okay, good question. And how long does the writ of reentry take? So if you were locked, you come home from work and you find yourself locked out, would it take days to be able to get back in, or would that process be immediate?
It's intended to be immediate, like it's intended to be for immediate relief, but of course it does, take some time because the tenant needs to go to the court, or right now, some courts are operating remotely, so tenants need to, navigate that. But generally it's intended to, have the writ sent out the same day. So it is a pretty quick procedure. One of the main barriers, of course, is that, if it happens after hours, or on the weekend, the court may be closed. So the tenant may not be able to pursue that immediately.
And one more question about that. You may not have the answer. And I agree that a lot of people are intimidated to go to the court. Sometimes people have past warrants, or sometimes people don't have documents that are their citizens. If you have some issues like this, will that be entangled in this, or is it a separate kind of thing that you shouldn't worry about, your warrants or documents?
That is a good question. I'm not entirely sure, and I would definitely suggest trying to connect with an attorney about those concerns.
Okay. Thank you for all this information. I have another question. My landlord has not threatened me with eviction, either verbally or in a written notice, but refuses to make repairs. And I'm concerned about the health and safety of my unit. I have considered leaving, but I don't have anywhere else to live. What would you advise?
Yeah, so tenants, if they are behind on rent, are pretty vulnerable when it comes to repairs because the Texas Property Code does require landlords to make health and safety repairs. But in order for a tenant to have recourse, they need to be current on rent when they request the repairs. Otherwise, they wouldn't have any legal remedies. It's still a good idea to document what's going on by taking pictures and notifying the landlord in writing. But if a tenant is behind on rent, they may not be able to pursue recourse. So then the best thing to do, and this is a good idea even if tenants are current on rent and requesting repairs, is to call, the local code enforcement agency. In San Marcos, they can reach out to the code department there. That way they can get an inspection and their landlord may be cited for health and safety violations. That property functions outside of, the Texas state repair laws. So the requirement to be current on rent wouldn't apply.
Okay, I see. And where can we find like the standards? Would it be online in a Texas website or code compliance for the city, or would it be in our lease? Like, which repairs are landlords required to make, and how can I differentiate if it's something that I should do or something that they're legally required to do?
Yeah, that's a good question. First, as far as specific repairs that they need to make, there are very few that are specifically mentioned in state law, but the state law does broadly require them to make issues that are a threat to the health and safety of a tenant. So obviously there's a lot of things that, we can say would fall under that category. State law does specifically require a landlord to, make repairs if the tenant doesn't have hot water, and to make sure that a tenant has certain security devices like, locks, as well as keyless bolting devices on exterior doors. Broader requirements can be found in city codes, where they exist. So specifically in San Marcos, I believe they should be able to find that on the San Marcos website. San Marcos, I believe, has adopted the International Property Maintenance Codes, which are pretty holistic. So there's a lot of different requirements there. I think the best option would be to call the code department and have them come out. There usually aren't going to be that many habitability requirements in a lease agreement. But again, if it's a threat to a tenant's health or safety, they should request that in writing.
Okay, I see. And there was a comment from Tiffany Harris from the city of San Marcos, who is the community vitality coordinator. So she's giving a phone number that you can call if you're in the city of San Marcos, 512-393-8479, or code compliance, one word, at sanmarcostx.gov to figure out what repairs the landlord must make. And there was another question from the audience. It says, my landlord recently started to use a new management company that charges $150 lease renewal fee. I feel this is predatory. Is there anything I can do about that?
Yeah, that does seem like a predatory practice. The problem is that there aren't really any limitations on fees. So if it's included, they can't add a fee in the middle of your lease term, like, oh, suddenly you have this additional bill that you have to pay every month. But if it's a condition of renewal and would be included as part of a new contract, unfortunately, there aren't any restrictions on that. One thing to consider is, are they applying it to everyone, or does it seem to be applied in a way that's discriminatory or retaliatory towards specific tenants? If it seems to be discriminatory, we could refer it to our fair housing department. But just in general, unfortunately, there aren't restrictions on fees like that. So if it's a condition of renewal, as opposed to something that's being added to the tenant's current lease term, then they can make that a requirement for renewing the lease. There may also be limitations if the tenant lives in federally subsidized housing, like a tax credit property or something like that.
Thank you. So I have only one more question that I have. So if other folks in the audience have any questions, please put them in the chat box and I'll read them out. I lost my job due to the COVID pandemic and I'm behind on rent. What financial assistance is available for renters like me?
Tenants can reach out for rental assistance at a number of different agencies and nonprofit and community organizations. The big one right now is the Texas Rent Relief Program. Tenants can apply for rent relief by going to texasrentrelief.com. So that's available to tenants statewide. Tenants can apply for up to 3 months of rental assistance at a time, and they can also reapply if funds are still available later on. That one, either tenants can apply, landlords can also apply if they're looking for rental assistance on behalf of tenants as well. So that's a big one. There's a lot of rental assistance available through that program. I believe that the Hays County, I believe Hays County is working on an emergency COVID-19 rental assistance fund that hasn't opened yet, but people can always connect with Hays County as well down the line to see when that will open. And again, you know, people can always reach out to us and we can try to help them find specific resources or let them know if new ones are available when they call.
Okay, well, I don't see any other follow-up questions in the audience box. And I have asked my final question. Is there any other information, Rachel, that you think is important that you thought of that you wanted to let us know?
I mean, just in general, tenants should always communicate with their landlord in writing. You know, we talked about the CDC eviction moratorium and how tenants are only protected if they communicate with their landlord in writing that they are covered by that. So again, you know, just always be sure to communicate with your landlord in writing, regardless of what the issue is. You should always have documentation of that as well. If you're having repair issues, take pictures of what's going on. Otherwise, I mean, you know, people can always connect with us and reach out. We have our telephone counseling line as well as online counseling, as well as a lot of this information on our website. So if people have other questions, they can always connect with us that way.
Okay, so just real quick, can you give us some general information on Austin Tenants Council, how to, what the general services you guys provide and how to reach out? Do we need to reach out to a specific person or is there a main line to call?
Yeah, so in general, our services primarily are for counseling and education purposes. So we'll educate tenants about tenant rights in Texas. People can reach out to us for counseling, you know, for information about what their rights are, what next steps they can take. They can either call our telephone counseling line. The number for that is 512-474-1961. So people can call that to speak with a counselor. We have been very busy, so there have been long wait times. I know a lot of people have been dealing with that. So a way to not have to wait on the counseling line would be people can submit an online counseling intake on our website. They would submit an intake and then a counselor will respond to them by email. Our website is housing-rights.org. In addition to our counseling services, that's what our tenant-landlord team provides, which is the team that I work for. We do have a fair housing team. They assist tenants with understanding their fair housing rights and handling discrimination, concerns, and complaints. So tenants can also either call our counseling line or submit the online fair housing intake form if they're concerned about discrimination.
Thank you. And there is a comment that I want to read from you in DM San Marcos, United Neighborhood Defense Movement. is working to help tenants in San Marcos. So if you're struggling with your landlord, reach out to them if you need help in San Marcos. And so I don't have any contact information if you want to put that in the chat box, a phone number or email or website, but we can definitely look that up later. That sounds like a great resource as well. Thank you, Rachel, for all this information. I think this has been so much to think about and to learn. And I think it's a crucial time right now. Before we take off, I do want to read the email to get in touch with United Neighborhood Defense Movement is undm-sanmarcos@protomail.com. Also undm/sanmarcos@proton mail.com. Oh, one more question. So sorry, don't leave yet. There are some small towns around Austin metro area. Can the small towns receive your help? For example, in Luling and Caldwell County?
So right now we serve Travis, Williamson, and Hayes counties. So people would need to live in one of those areas to be eligible for our counseling services. Our fair housing department serves a much broader area. So if people have fair housing concerns, there's a good chance they would be served by our fair housing department. They can contact us and we can let them know if they'd be covered or if there's another fair housing agency. But yeah, our telephone counseling services and online would be limited to Travis, Williamson, and Hayes counties.
Okay, thank you. And we have a phone number for you in DM. It is 512-337-6846. Well, I see there's no other questions popping up, and I have a lot of notes to consider and learn and things to look up. So thank you, Rachel, for your time, and thank you everybody who's contributed. I'm going to go ahead and turn off the recording. We can stay in chat for longer if we need to, and we'll also be posting this in Spanish. So look out for that on our YouTube channel. Thank you.